Oh,
There you go.
okay. We'll, if everybody could take their seats, we'll get started. I want to welcome everybody to the Joint Government Operations Committee Rule Review. This is July the 23rd, 2025. And before, before we get started, let's take the roll first. Madam Clerk, would you take the roll?
Senator Bowling is present. Senator Crowe is present. Senator Hatcher, Senator Kyle, Senator Oliver, Senator Rose is present. Senator Seal, Senator Sutherland is present. Chairman Jackson
Here.
is present. Chairman, you have 5 present. Representative Hardaway is Representative Clemens is present. Representative Crawford is present. Representative Faison is present. Representative Fritz, Representative Glenn, Representative Helton Haynes is present. Representative Mayberry, Representative Rudder is present. Representative McKenzie is present. Representative Parkinson, Representative Reedy is present. Representative Renault is present. Representative Sherrill, Representative Towns, Chairman Lafferty is present. Chairman, you have 10 present.
Thank you, Madam Clerk. It looks like we have a quorum in both Senate and the House. Oh, since before we get started, we do have any announcements or recognitions? Yes, sir. Mr. Senator Rose, you're recognized.
Thank you, Mr. Chairman. I think the world should know, along with this committee, that Monday was your birthday. And although he doesn't look like it, he is older than I am. Happy birthday.
Thank you. Thank you very much for that. It was a great day. Got to spend some time with the family and have some fun. So thank you very much. Okay. Let's see. Do all the members have their microphones logged in? I want to be sure that everybody's got that done. We do have a sign-up sheet over here to my right. Anybody has public comment, so we have that ability to do that. So sign-up sheet. Let's see. Today we have 12 items on the agenda, so we will go ahead and get started with the first one, the Tennessee Board of Utility Regulations. If they will come forward, take a seat at the table. Make sure your mic is on, and then be sure you tell who you're with and your name and who you're with before you speak. And you may begin.
Good afternoon. My name is Edwin Carter. I'm a legislative senior auditor with the Comptroller's Office. I also serve on the Tennessee Board of Utility Regulation as a Comptroller appointee. To my left, I have Rachel Buckley, who is our General Counsel for the Comptroller's Office. And further left is Nate Fontenot, who is a financial analyst for the Comptroller's Office, and he also serves as staff to the TBOR. Rachel is going to talk to you about our rules for the TBOR.
Yes, thank you, committee, Mr. Chairman. Again, Rachel Buckley for the Comptroller's Office. In 2023, a law was passed that combined the Utility Management Review Board and the Water and Wastewater Financing Board into one board, the Tennessee Board of Utility Regulation, as we call it, TBOR. These rules simply repeal the old rules that were applicable to those old boards that no longer exist and replace it with new rules applicable to TBOR. They simply govern the operations of the board. They were subject to a rulemaking hearing, and we did not receive any public comment at that hearing. I think you probably have received a summary of these rules, so I want to be respectful of the committee's time. So I'm not going to belabor that, but if you have any questions, we'd be happy to answer those.
Motion, and then a second. What we need to do first is have public comment. Any public comment? Representative Clemens, you're recognized.
Thank you, Mr. Chair. So this combines multiple specialties within the utility industry. So can you speak to me as to what the appointees to the board, if they have the specialty required to govern those issues if the board is fully appointed and what the board looks like.
Sure, I can give you broad strokes. I may have to ask for some assistance here. Those appointees are mostly the governor. The comptroller does have some. The TBOR has jurisdiction over the finances and the management of the public utilities in Tennessee, so government-owned utilities. Those appointees typically have to be either from a utility district, from a municipal utility. There is a TDEC appointee on the board, there are a couple of appointees with finance backgrounds as well.
You're
Thank you,
recognized.
Mr. Chairman.
You
So-
can continue.
Thank you, Mr. Chairman. So you're comfortable that all the specialties and areas of subject matter covered by this organization is covered with members of the board?
Yes.
Thank you.
Thank you. Any other members have any questions? See? Representative Hardaway, you're recognized.
Thank you, Mr. Chair. Just two questions. Does it have anything to do with MLG and W?
Do the rules have anything to do with MLGW? They're, to the extent they have they do have water. So the finances of their water system could fall under the jurisdiction of the board, but these rules govern just the board's procedures.
And the second one is, what's the impact on Blue Oval?
You know.
We do want to stay germane to the rule, but you
Mr. Chairman,
go ahead
if
and
it doesn't,
answer the
the simple-
question.
Yeah,
You may go ahead and answer the question.
Sure. Thank you, sir, for your question. There's no direct impact on Louisville City, to my knowledge. There are some
Thank you.
local utilities in the area.
Thank you. Anyone else have any questions? Seeing none, we have had a motion and a second. What we'll do is have a voice vote in the House. All in favor say aye. All opposed? Ayes have it. Roll call in the Senate. Madam Clerk, take the roll.
Senator Bowling? Votes aye. Senator Crow? Votes aye. Senator Hatcher? Senator Kyle? Senator Oliver? Votes aye. Senator Rose? Votes aye. Senator Seal? Senator Sutherland? Votes aye. Chairman Jackson?
Aye.
Votes aye. Chairman, you have 6 ayes.
Thank you. And so this rule will move out with a positive recommendation. Okay, second, next is the Tennessee Housing Development Agency. If you will come forward and take a seat. And again, just identify yourself, who you're with before you speak, and you may begin.
Thank you, Mr. Chair. Members, my name is Jeremy Hyde. I'm the Director of Government Affairs for the Tennessee Housing Development Agency. With me, I have Pasquale McLeod. She's our Assistant Director for our Section 8. And next to her is Charity Williams. She is our Assistant Legal Counsel. Our program that we're bringing the rule forward is about our Section 8 program, and I'm going to defer to Pasquale to explain that.
You're recognized.
Thank you. Good afternoon to everyone assembled here today, and thank you for the opportunity to provide you with a general overview of the regulatory updates made to the Housing Choice Voucher Administrative Plan that is administered by THDA. THDA administers the Housing Choice Voucher HCV program to more than 6,200 families in 72 Tennessee counties. THDA continues to expand housing opportunities through successful administration of the HCV program. HUD allows a PHA to project base a percentage of its housing choice vouchers through the project-based voucher PBV program. The PBV program is a critical component of THDA's efforts to provide decent, safe, and affordable housing options to low-income families and individuals within our community. Established in 1998, the PBV program allows for the allocation of housing vouchers to specific housing developments, thereby ensuring a stable, sustainable source of affordable housing units for eligible participants. HUD requires all PBV administrators to include a policy chapter within its administrative plan that outlines the program and how it will be administered. These rules have been developed with the aim of enhancing the efficiency, transparency, and effectiveness of the program, while maintaining compliance with federal regulations and local housing policies. This concludes our presentation of the rule, subject to your questions. Thank you again for the opportunity to appear before you today.
Thank you. Representative McKenzie, you're recognized.
Thank you, Mr. Chair. And thank you for that explanation. But I'm just trying to get my arms around what exactly is changing. It sounds like, so let me lay out a scenario and tell me if I'm in error or not. Sounds like we're going to take a percentage. I'd like to know what that percentage is, but a percentage of vouchers that say you can move into this house in this neighborhood and give it to either the housing authorities or other developers to build more project type of concentrated housing. Is that what this change is? And if so, why would we do that?
You're recognized to respond.
It's an effort to take some of the vouchers that we do have and make them available, again, for development, to basically give a property that has a unit that will have that voucher assigned to that unit, so that it doesn't have to be someone who finds it. Right now, we have approximately 600 voucher holders across the state who cannot find a landlord to take the voucher. So this is an opportunity for us to create more housing that would be available for eligible participants.
You're recognized. You
thank
may
you.
continue.
Okay, thank you. What two questions and I'll be done. So what percentage are you all planning on taking? This says 8% at this point. What percentage of those vouchers? And has history proven that concentrating our vouchers, which probably, not probably, will be poor people, is that been proven effective in trying to create these more, again, project type environments as opposed to having houses in neighborhoods with vouchers?
Thank you. I can speak to the percentage. So HUD allows us to project base up to 20% of our housing choice voucher allocation to project-based vouchers. We plan to start with an initial 5% with the hope to increase up to the 20%.
Any other questions?
Just so we are monitoring that, and as that goes in, we'll look at some of the research for that. I don't know that we have anything specific on that concentration you're talking about, because it is, again, to develop new housing and hopefully create more things. We'll have an application process for people to apply for those units.
I'm going to go to Representative Chairman Lafferty first, and then Clements.
Thank you, Chairman. Did I hear you say 6,200 families in the state, or 62,000?
6,200.
60, okay, thank you. Is there an average length of time that folks use these funds? I would hope that everybody was wanting to get their own place at some point. Is there an average length of time that you're aware of that people stay on these systems, on these assistance programs?
When we issue a housing choice voucher, it is issued indefinitely to the family. So as they become self-sufficient and no longer need the assistance, then they are able to exit the program.
Okay, thank you for that.
You're
And
welcome.
I came across a term, administrative fee reserve. Could you tell me a little bit about what an administrative fee reserve is? I'm sure I read it, or I don't know how I would have written it down on my questions here.
We do get administrative fees to administer the program from HUD. And so that's just a fee that's paid to THDA to administer that program.
Okay, I guess I saw the word reserve, that indicated to me that maybe there's a bucket of money somewhere that set aside for something.
I believe I know what you are referring to. So we do have with HUD. So if we do not use all of the funding that is allocated to us, there is a reserve account that holds those funds that we have not used.
Okay, thank you. Just a couple more questions if I could.
Yes, you may
I'll try and be
continue,
quick.
please.
Davis-Bacon wages. Could you tell me what that means? I saw that about, I think, around construction, maybe. Could you tell me what that relates to?
I believe that's a federal wage rule.
Okay. So if that federal wage is higher than what we can hire somebody to do the job in the state of Tennessee, then we're kind of artificially increasing the cost of housing. Is that a fair statement?
I don't know. I don't think I can address that as a fair. It's just that we have to follow that federal law.
Okay. Okay. And then the other term, and this will be my last one, Chairman, thank you. Vacancy payments, are those limited in duration?
So for this administrative plan, so with the vacancy claim payments, we did not adopt that policy. And what that policy is if a landlord has a vacant unit, that we will pay the subsidy for that unit until he houses another, he or she houses another tenant. But since in this policy that we have adopted, the landlords are responsible for maintaining their own waiting list, so we did not adopt the vacancy claim payment.
Okay, wonderful. Thank you. All right, thank you, Chairman.
Yeah, thank you. Okay, next, Representative Clemens. We're going to go to Representative Clemens, then Hardaway, then Senator Oliver. So Representative Clemens, you're recognized.
Thank you, Mr. Chairman. And first of all, thank you for the service that you provide. It's a vital service and it's badly needed in every community across the state of Tennessee. Affordable housing is an issue, not just in urban areas, but in rural areas, as I've learned firsthand from traveling around the state over the past few years. Access to housing is a serious issue. One of the things in researching this that we've come to find is, there's often too few vouchers available, and also the issue that you raised where landlords are not willing to take the vouchers. So my questions are, is this rule in any way limiting or cutting the number of vouchers?
No, sir.
Is this rule in any way helping assist those with getting housing, facing the issue with the landlord bias or prejudice issue that we continue to see, and an unwillingness to accept vouchers?
I think so. Yeah, that would be, again, that would be a unit that has a voucher attached to it. So it would be easier for a person to get in there. They don't have to search out and find that one on their own. It's already attached to that unit.
So my last follow-up is, just in conclusion, is this rule going to assist individuals in every part of the state, urban, rural, suburban, get access to affordable housing to the extent the fund allows?
Absolutely. And we are, the counties that we administer are outside of the general metro areas. So this would be mostly the rural communities, areas not served by their own public housing authority.
Right. All right. Thank you. Thank you, Mr. Chairman.
Representative Hardaway, you're recognized.
Thank you, Chairman, and good afternoon to you. The issue of density has been a big deal for Memphis and Shelby County. Are any of the areas that are going to receive or be eligible for these funds, will those areas be able to use condos for their residential listing?
Possibly, but there's also eligible housing types. Additionally, Memphis Housing Authority has their own public housing authority, so these vouchers would not be going into the Memphis area.
Thank you. And recognizing that the issue of density is one that plagues more than just Memphis Shelby. That's what I was getting to. And that 6,200 is the number of families who are receiving or on the waiting list.
Receiving.
And is there a waiting list that you have?
Yes, sir.
Yes.
And how many are on that waiting list?
Quite a bit.
I believe we
Okay,
have
if you
over 9,000 families that are currently on a waiting list. It is significant.
All right. And are you projecting how this will impact the waiting list? How many and what period of time?
One of the policies that we have adopted with project-based vouchers is all of the families that are on our current HCV waiting list will have the opportunity to apply for the project-based voucher waiting list.
All right, and will this involve new construction also? And that new construction, I'll go back to density and multifamily condos as opposed to apartments.
As of right now, there's no minimum project cap in our administrative plan. And so if we have a developer that comes to us, then that may be a possibility.
All right, and would that one developer have to administer or contract for the whole building? Or would each individual condo owner be able to contract with y'all?
It will be a percentage of the development.
All right. All right. Thank you. I'd like to get more information on that. If you could get it to the chairman and share it with the committee, please. Thank you, Chairman.
Thank you. And Senator Oliver, you're recognized.
Thank you, Mr. Chairman. With this rule change, does this in any way change the payment going directly to the family recipient, or will the money be going to the developer or landlord?
It always goes to the landlord.
Okay. So with that, will this rule change any piece of the assistance amount being reduced over the course of this program? Will the rental assistance amount reduce in any way?
No, that's set by HUD as well.
Okay. Okay. And you mentioned you would like to see the percentage go from 5% up to 20% over the course of time. What would precipitate that percentage going up?
So we are anticipating, we do have a lot of interest in the project-based voucher program. So we anticipate being able to reach out to HUD once we allocate the first round of 350. We do anticipate reaching back out to HUD and letting them know we would like to increase that cap.
Okay. Okay. With the payments going straight to the landlord, what assurances are in place right now that those payments are paid on time?
Our funding goes through Edison, and so we make sure that those are sent on time. And it's set up in our administrative plan that if for some reason the payment is late, the tenant is not impacted by that.
Okay. Thank you, Mr. Chairman.
Thank you. Members, Representative Hardaway, you're recognized for another question.
Thank you, Mr. Chairman. Just a concern that just came to me. Could these funds be clawed back by the feds? And if so, are we prepared to make up the difference?
Not at this time, and I don't know that we could make up the difference.
But is there any type of ironclad assurance that the feds couldn't snatch this money back?
Not that I'm aware of. I know that the THUD and the federal system is going through the appropriations process right now for HUD. That's all I can say. I don't know what their plans are.
Okay, we probably need some contingencies, don't we? You can answer that with an email to the chairman. Okay. Thank you, Mr. Chairman.
Thank you, Representative Renaud. You're recognized.
Thank you, Mr. Chairman. Forgive me, I am unaware of maybe the genesis of this particular program, but the folks that are signing up for this project, do they get an incentive, the developers, do they get an incentive to participate in this program to make their development available to the voucher program?
I think part of the program is that they do get a funding stream through this voucher.
Right after they get that for the rent, but is there any other incentive that they get prior to that?
It would depend on the development. If they are participating in other programs, that's possible.
So is there a requirement for a length of time that the voucher is attached to the property? In other words, is someone, what I'm asking is if there's a developer who's getting some sort of monies or incentive to start this program, but then they use the voucher program for maybe a year or two and then decide to take that property and sell it for profit, then you might lose that property for someone who is really needing that voucher, but then they get to turn it over.
Our programs that we do construction through, like the low-income housing tax credit program, they have a 15-year compliance period, as well as we typically have another 15-year added onto that for a total of 30 years of commitment for some of those funding. So there might be those issues involved. It just depends on the deal.
Okay, thank you.
Members, any other questions? Seeing none. Before we get to ask for a motion, any public comment? Seeing none. So now I need a motion for, have a motion and a second for a positive recommendation. So first, we will go roll call vote in the Senate. Madam Clerk, take the roll call vote.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland votes aye. Chairman Jackson
Aye.
votes aye. Chairman, you have 6 ayes.
Thank you. And in the House, all those in favor say aye. All opposed? Ayes have it. This bill passes through with a positive recommendation. Thank you very much. Next, third item on the agenda is the Tennessee Fish and Wildlife Commission. If you'll move forward, and I think you know the drill. You can identify yourself and you may begin. Make sure your mic is on. There you go.
Thank you, Chairman. Blair Beatty, Legislative Director with the Tennessee Wildlife Resources Agency. The proposed rule before you today updates language to provide clarity and consistency in the terminology with other recent rule changes and with language used in the agency's annual hunting guide. Namely, the rule incorporates terminology, related to Tier 3 hunt locations, also referred to as quota permit areas, to reflect that these areas are not permanent blind locations, but instead are pool locations. There is no change in regulation or operation of these areas, so no change for our sportsmen or customers. The proposed rule did not receive any public comment and is not anticipated to impact small businesses or local and state government revenues or expenditures. And with that, Chairman, I'm happy to answer any questions.
Thank you. Members, heard the description of the bill. Any questions?
I'm still here.
Seeing none, I've had a motion. That's if we had any public comment. Seeing none. Motion for approval. Been approved, seconded. Okay. Now, Madam Clerk, if you'll take a voice vote in the House. I'm sorry. All in favor in the House, say aye. Aye. Opposed, say no. Ayes have it. Roll call vote in the Senate, please. Madam Clerk.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland votes aye. Chairman Jackson
Aye.
votes aye. Chairman, you have 6 ayes.
Thank you. This rule moves out with a positive recommendation. Okay, item number 4, which is the Department of Children's Services. If you'll move forward and take a seat, turn your mic on and identify yourself, please. And you may begin.
Thank you, Chairman and committee members. My name is Jim Lehman. I'm the Legislative Director for the Department of Children's Services. I have with me Sammy Mayfair, our General Counsel. We are here today for updates for our rules regarding access to public records for DCS. This rule was identified through our recent retrospective rule review process that all the departments went through. These rules haven't been updated since 2006. So in that time, the Office of Open Records Counsel with the Comptroller's Office has established a model public records policy. So primarily the changes to our records include updates to more closely align with that model policy from the Office of Open Records Counsel. Specific updates include things about changes to procedures for requesting copies of records, fees and charges for public records, and how DCS will handle aggregation of frequent and multiple public records requests. So with that, Chairman, we'd ask for a positive recommendation, and we're happy to answer any questions you may have.
Thank you for that. And members, questions? Representative Renaud, you're recognized.
Thank you, Chairman. Mr. Lehman, does the department allow for digital copies at all?
Go ahead.
Yes, we do. That is provided for in these rules, that electronic copies may be provided at no cost, except for perhaps if there's a flash drive requested, equipment associated with it.
Thank you.
Representative Clemens, you're recognized.
Thank you, Mr. Chairman. Just a few questions. Does this new rule limit access to these records in any way? beyond what they're currently available?
I don't think they limit them in any way, any more than the previous rule had or anything that's beyond, statutory limitations, like regarding confidentiality of certain children's records and that sort of thing. None of the changes were made to limit access to records or anything like that.
Thank you, Mr. Chairman. And do any of these new rules increase cost to those requesting those records in any way?
The costs are aligned with what was with the model. Our rules before just said that we could charge reasonable costs, and this just says specifically what those costs are in accordance with the Comptroller of the Treasury's recommended model.
Yeah,
rules.
the Office of Open Records Council has a fee schedule for how to charge for access to public records for labor time and all that sort of thing.
And these rules are in alignment with those standardized fees and rates?
Yes, Chairman.
And my last one is, there was an issue in here where the department will not certify the accuracy or authenticity of an individual making copies of their own. But I didn't see any allowance in here for the certification of authenticity if the department is requested to make those copies. As you know, this comes into play quite a bit in legal matters and litigation. So I just want to make sure that the department will and is willing to do that.
Yes, and we do routinely do that. We will provide the certification from our records custodian if we are the ones that have provided the copies.
Thank you very much, Mr. Chairman.
Thank you. Members, any other questions? Representative Hardaway, you're recognized.
Thank you, Chairman, and good afternoon. Do these rules address indigency?
They don't expressly address indigency. However, if the fees are under $50, those may be waived at our discretion. If they are over $50, the individuals can make a request for the waiver of fees, and we would evaluate that request.
Do these rules set out the criteria for your evaluation?
Not specifically, no.
Is it subjective, objective? Is that written anywhere?
These rules just simply address the fact that it is in the discretion of the agency and the public records custodian.
All right, Mr. Chairman, I'm concerned about that. We ought to have something in writing somewhere that addresses those organizations and individuals who may not be able to access what's otherwise public information. So I would ask that the respondents would contact the chairman and send him some kind of indication on how you could address that and whether it would require legislative action. Thank you, Chairman.
All right. Thank you. Members, any other questions? Yep, you're recognized.
Thank you, Mr. Chairman. In your report, I must have missed it, or I couldn't see it, or I didn't hear you say anything about having a public hearing on these rules. Did you have a public hearing, and what was the response?
Yes, sir. Sorry, I did fail to mention that. Yes, we had a public rulemaking hearing in December of last year. Was it December 6th? December 2nd of last year. We did not have any attendees at the hearing, no public comment. Apologies for not mentioning that earlier.
Thank you. Members, any other questions? Seeing none, do we have any public comments on this rule? Seeing none, I have a motion for a positive recommendation. I have a second. Okay, what we'll do first is a voice vote in the House. All in favor say aye. All opposed, no. The ayes have it. Roll call vote in the Senate. Madam Clerk, take the vote.
Senator Bowling votes aye. Senator Crowe, Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland votes aye. Chairman Jackson
Aye.
votes aye. Chairman, you have 5 ayes.
Thank you. And this rule moves out with a positive recommendation. All right. Next is item number 5, Tennessee Real Estate Appraiser Commission. If you'll just come forward and take a seat and identify yourself, and you may begin.
Good afternoon, Mr. Chairman and members. Reed Witcher, I'm the Assistant Commissioner for the Division of Regulatory Boards of Commerce and Insurance, joined by Glenn Kopchak, who's the Executive Director of the Tennessee Real Estate Appraiser Commission. The commission is audited biennially to ensure compliance with federal appraisal requirements. These audits ensure that Tennessee appraisers are eligible to conduct appraisals of VA and FHA loans. These rules address recommendations from the commission's 2023 audit. Excuse me. The rules provide additional flexibility for trainee appraisers to conduct inspections alone prior to achieving 500 hours of experience. Before conducting those inspections alone, the trainee and their supervising appraiser must provide notice to the board that the trainee is competent to inspect the property. The rules eliminate the commission's license upgrade fee and temporary authorization fee. They also reduce the commission's reciprocal license fee to be the same amount as the initial license fee. These application fees that are being eliminated or reduced haven't been utilized since around 2018. The commission conducted a rulemaking hearing on January 21st, 2025, and no public comments were received. With that, we're happy to take any questions.
Thank you. Members, you heard an explanation of the bill, of the rule. Representative McKenzie, you're recognized.
Thank you, Mr. Chair. And so for someone in state practicing in state, there's a fee, correct? And then someone that's out of state that you're doing a reciprocity on, you're reducing that fee.
So the reciprocal license fee has been $25 more than the application to just directly apply with the commission. In practice, we don't utilize a reciprocal application for someone who's already licensed in another state. We have a single application that essentially has guided questions that has you provide all the information that you need to provide. So if you're already licensed in another jurisdiction, whether you're a Tennessee resident or a resident of another state, you would provide that information, and that goes into the commission's process for vetting a candidate. So the reciprocal license fee is a fee that's not currently being charged because every licensee is utilizing the commission's initial application at this time.
Response?
Yeah, so then fundamentally, then I'll respond. I guess I really like helping Tennesseans that are in Tennessee, living in Tennessee, paying our taxes in Tennessee, pumping gas in Tennessee. I would rather give them some type of break as opposed to someone that may be practicing in 5 states, 2 states, 8 states. And so I would just ask y'all to consider, as we're redistributing these funds, that I get that there's an initial application fee, that be tiered at some level. So that's my concern, and just asking for consideration as you move forward and making sure that we're taking care of folks that live, work, and play here. Thank you.
Chairman Lafferty, you're recognized.
Thank you, Mr. Chairman. Just a curiosity, with the technology coming on like it is, I'm on Zillow a lot. How solid is the future of the appraisal industry? Just from you guys see it from the 1,000-foot view. Just curious your thoughts.
Yeah, just to be sure and identify yourself when you speak.
Yes, sir. Glenn Kopchak, Executive Director of the Tennessee Real Estate Appraiser Commission. I'm not an appraiser, so I would absolutely be speculating. But what I have heard some of the appraisers say is that they get on the upside and the downside. So the market is fluctuating, but they have to evaluate it on each whatever swing. And so it seems like it's holding pretty steady. And I haven't seen anything that we can only measure that in licensees. And so we stay in our lane. And right now, we haven't seen any dramatic dips or anything to concern us at this point.
Okay. Thank you. Thank you, Chairman.
Thank you. Members, any other questions? Seeing none. Is there public comment? Seeing none. I need a motion. I have a motion for positive recommendation. I have a second. We will take a vote. Have a roll call vote in the Senate. Madam Clerk, if you'll take the roll.
Senator Bowling votes aye. Senator Crowe, Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland votes aye. Chairman Jackson
Aye.
votes aye. Chairman, you have 5 ayes.
Thank you. We'll have a voice vote in the House. All in favor, say aye. All opposed? Ayes have it. This rule passes with a positive recommendation. Thank you very much for being here. Okay, next we go to the item number 6 on the agenda, which is Tennessee Emergency Communications, Benjamin Glover Board, Department of Commerce and Insurance. If you'll just come forward, take a seat. Be sure your mic is on, identify yourself, and you may begin.
Good afternoon, Mr. Chairman, members of the committee. My name is Benjamin Glover, and I serve as Assistant Director and General Counsel for the Tennessee Emergency Communications Board. With me is Executive Director Curtis Sutton. Through the retrospective rule review process, the board identified an opportunity to repeal some outdated language within our rules. This update includes repealing details of a one-time increase of the base funding for local 911 districts that concluded in 2016. Additionally, these rules update the definition of special distribution to include a statutory reference to more accurately indicate what distributions are not under the purview of the rule. The board conducted a rulemaking hearing on December 4th, 2024, and received no public comments. We'd be happy to answer any questions you might have.
Thank you. Members, you've heard an explanation of the rule. Any questions? Seeing none. Have any public comment? Seeing none. Have a motion for positive recommendation and a second. First, we'll go to roll call vote in the Senate. Madam Clerk, take the vote.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland votes aye. Chairman Jackson
Aye.
votes aye. Chairman, you have 6 ayes.
Thank you. And take a voice vote in the House. All in favor, say aye. Opposed? Ayes have it. This rule will move out with a positive, this rule was moved out with a positive recommendation. Thank you very much. Okay, item number 7, Department of Health, Board of Optometry. If you'll come forward and take your seat, make sure your mic's on and identify yourself and you may begin.
Good afternoon, Chairman. My name is Olivia Johnson. I'm a legislative liaison for the Department of Health. I'm joined by Catherine Trewick, Board Attorney, and Dr. Tharp, Board Chair. This rule is amending Rule 1045-2-.08 to update the parameters for advertising optometric services. The new definition is clear in what constitutes an advertisement of ophthalmic goods or professional optometric services. The proposed rule also adds definitions in regards to patient encounters and divides the patient encounters into 2 categories. The first is a vision care encounter, where the patient presents with a chief complaint for the measurement of the vision system. The encounter could result in the determination of whether prescribing ophthalmic correction is needed to remedy or relieve the defects in vision performance. This could include spectacle eyeglasses or contact lenses. The second kind of patient encounter is where the patient presents with a chief complaint related to eye health issues that affect the ocular or systemic health and require testing, diagnosing, treating, and managing conditions related to the health and preservation of the eye and related structures. This proposed rule also expands the definition of a healthcare provider to include optometry graduates and students who meet certain criteria so that the rule will comply with statute. And lastly, this proposed rule creates Rule 1045-2-.19, which requires licensees to provide proof of an address or name change within 30 days of that change, allowing for an increased ability to contact the licensees regarding licensure issues. This is standard in all of our health-related boards. There were no public comments on these rule changes, and the board voted unanimously for them. At this time, we're happy to answer any questions that you have.
Thank you. Members, you've heard the explanation of the rule. Senator Crowe, you're recognized.
So basically, what are you doing? Yeah, just tell us in layman's terms what you're doing.
Sure. So there's a couple different things that this rule packet is doing. The first one is that it is changing, updating some rules to streamline advertising. There's a couple of redundancies, so it's removing those redundancies. The second thing is changing the definition of patient encounters into 2 buckets, one being vision related, things like spectacles, contacts, that kind of thing. And the other is being eye health encounters. Those are things that are for the ocular system. And then also the biggest thing that
is probably going to be very helpful for our board, is it requires any address or name change of licensees for the board to be alerted within 30 days. So that way our board can contact them.
Senator Crowe? Okay. All right. Any other questions? Representative Renaud, you're recognized.
Thank you, Mr. Chairman. On the, let's see, it's page 20 of the rules, item number 9 about the objective and subjective refractions. Would this requirement prevent someone who could not give a subjective refraction where the patient could not say or confirm the objective refraction exam, prevent them from being able to get glasses? Like someone in, for example, that might have an altered mental state or in a nursing home where they could not really give the feedback.
No, it would not prevent that. That person could still get a prescription for glasses and contact lenses if they were not able to respond subjectively, because there are other means of getting objective data.
All right, thank you very much.
Sure.
Thank you. Members, any other questions? Seeing none. Is there public comment? Seeing none. I need a recommendation. Have a motion for positive recommendation. Second. May we take a roll call vote in the Senate, please? Madam Clerk, take the roll.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland, Chairman Jackson
Aye.
votes aye. Chairman, you have 5 ayes.
Thank you. And we'll take a voice vote in the House. All in favor say aye. Opposed? Ayes have it. This rule will move, did I ask for public comment? Okay. This rule will move out with a positive recommendation, and thank you very much. Okay, next, members, we are going to go to the Tennessee Board of Communication Disorders and Sciences Council for Licensing Hearing Instrument Specialists. If you'll come forward, take your seat, be sure and identify yourself, and you may begin.
Olivia Johnson, Legislative Liaison, Department of Health. I'm now joined by Michael Barnell, Board Attorney. This rule is a part of our retrospective rule review project. For those of you that are unfamiliar with that, the governor's office asked us to go through and repeal redundant and or duplicative citations. So this rule would be repealing Rule 1370-02-.03 because it is repetitive to what is currently in statute, and it is found in TCA 63-17-205. The repealed rule that is found in statute pertains to the necessity of licensure and states that unless an individual holds a current, unrevoked, or unsuspended Tennessee license, he or she may or not engage in the sale or practice of dispensing or fitting hearing instruments. The board voted unanimously in favor of this rule repeal, and there were no public comments. At this time, we're happy to answer any questions that you have.
Thank you. Members, you've heard the explanation of the rule. Any questions from any of the members? Seeing none. Is there public comment? Seeing none. I have a motion for positive recommendation. Do I have a second? Second from Chairman Lafferty. Members, let's see, we'll do a roll call vote in the Senate first. Madam Clerk, take the roll.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland, Chairman Jackson
Aye.
votes aye. Chairman, you have 5 ayes.
Thank you. We'll do a voice vote in the House. All in favor say aye. All opposed? The ayes have it. This rule moves out with a positive recommendation. Thank you very much. Okay, next, item number 9, Tennessee Health Facilities Commission. If you'll come forward.
And if you'll just say the page number, because some of the members, I guess.
Okay. Members, this is on page number 201, if you wanted to follow along with this.
Good afternoon, Chairman and committee members. My name is Katie.
If you would pull your mic a little closer, I think we're having
Good afternoon. Is that better?
that's perfect. Thank you.
afternoon.
Yes, thank you.
My name is Katie Thomas with the Health Facilities Commission. These rules apply to the abuse registry. They update the responsible agencies to the Health Facilities Commission from the Department of Health. The definition of abuse was amended to reflect the change in the federal definition, and the definition of willful was added to clarify what must occur for a registry placement. I'm happy to answer any questions.
Thank you, members. You've heard an explanation of the rule. Any questions? Seeing none. Representative Hardaway, I'm sorry. Oh. Hardaway? Okay. Representative Glenn, you're recognized.
Thank you, Mr. Chairman. Can you break that down in the third grade for me? I'm just trying to figure that one out.
Yeah, absolutely. So the abuse registry is for individuals who have abused vulnerable people. So the abuse definition was a little bit limited, and the federal definition expands it to current practice of what we have been doing.
You make it. Follow up?
Yes, sir. Thank you, Mr. Chairman. You said to what you have been, and what is that? What is that you have been doing?
All that our Deputy General Counsel, Nathaniel Flinch, will answer that.
Good afternoon, members. Nathaniel Flinchbell, Deputy General Counsel with the Health Facilities Commission. So what's happened is, as the CMS Certified State Survey Agency, the commission, all of our CMS certified facilities are required to follow the federal definition of abuse. We have always practiced what is now in writing. So abuse always consisted of sexual abuse, verbal abuse, but now it's specifically laid out in the definition. So essentially it took what was practice and made it clear in the language so that everything, the other change that it made was it started to include technology. So we're seeing in facilities some exploitation, some abuse by individuals through the use of technology, streaming services and things. And so it makes it clear that use or misuse of images or live streaming of an individual who would be considered vulnerable would subject the person to placement.
Follow up? Go ahead. Representative Hardaway, you're recognized.
Thank you, Chairman. Good afternoon to you. The term abuse, as it's been redefined, would it also apply for any civil actions that these individuals may be found guilty of?
So Representative Hardaway, so the abuse registry is for one purpose and one purpose only, and that's for notification to facilities that receive state or federal funds. When they go to employ an individual, they check the abuse registry. If they're on the abuse registry, they're not allowed to employ the individual unless they can prove that employment is not tied to any receipt of federal or state funds. So outside of what you have here, there could be tort actions, but the abuse registry placement serves no purpose for any type of tort.
Follow up?
Yes, sir. I'm not sure if I asked the wrong question or you gave the wrong answer. Okay. But if you have an individual, there's been a tort action, they've had to pay up, or there's been some type of court action that said, don't do this anymore to this protected class. Do these rules apply to those type of civil actions?
So not directly. So essentially when the commission would receive a report that a tort was paid out, if it was in, for our rules, a licensed healthcare facility, we would use that as a basis for a complaint to go in and do an investigation, which we would then substantiate. So the civil side, it would be a complaint. We do receive referrals from TBI and the courts for criminal placements for any type of criminal action that resulted in placement on the registry. So they're treated a little bit different between criminal and civil law. But yeah, the civil monetary that would be issued through a civil court would not be basis for placement, but it would be a basis for a complaint for us to go in and do an investigation.
To follow up?
Yes, so there is no registry for those that you would investigate and find that it was legitimate. The courts were legitimizing actions that they were guilty of and abusing the individual. So there's nothing that's going to compile the list of those individuals. This is only for criminal.
No, so the reason we would take that civil judgment and do an investigation would be to substantiate it so that they could be placed. So the judgment itself would not be sufficient basis in a civil version would not be the basis for a placement. We would have to do our own investigation to substantiate it. Criminal side, the court system is allowed to place under their criminal statutes.
And if it's substantiated, will that person's name go on this registry?
Yes, sir.
Okay, thank you.
Thank you. Members, any other questions? Yes, Chairman Lafferty, you're recognized.
Thank you, Chairman. I heard you say a second ago, I think, that the registry was available to entities, facilities that receive federal or state funds. Do private facilities also have access to this?
Yeah,
Okay.
so the registry itself, the list of placed individuals is available publicly through, we're still piggybacking off of the health website so that it's still found in the same place it has been. But yeah, the placements and the placing agency, the information containing to the placement is available publicly.
Thought it was, just wanted to hear you say thank you.
Yes, sir.
Thank you, Chairman.
Okay. Members, any other questions? Seeing none, is there a public comment? Seeing none, I need a motion. Motion for positive recommendation and a second. Have a second? Okay, we're good. So this rule, let's see, what I need to do is I'll take a roll call vote in the Senate. Madam Clerk, take the vote.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland, Chairman Jackson
Aye.
votes aye. Chairman, you have 5 ayes.
Thank you. And a voice vote in the House. All in favor say aye. All opposed? Ayes have it. This rule will move out with a positive recommendation. Thank you very much. Okay, item number 10 on the roll is Tennessee Public Charter School Commission. If you'll come forward and take a seat, and again, identify yourself and who you're with, and you may begin.
Thank you, Mr. Chairman and members of the committee. I'm Hayden Pendergrass, the Director of External Affairs for the Charter School Commission. And with me, I have our General Counsel, Ashley Thomas. So before you today, our proposed rule would correct an inadvertent inclusion of language when the rule was originally passed. The Charter Schools Act of 2002 allows for a 30-day reconciliation period following the approval of a New Start charter school appeal to allow the charter school to negotiate with the geographic LEA as to whether or not they will serve as their authorizer. In statute, this reconciliation period is only allowed for New Start charter school appeals and not for renewal appeals. When this rule was originally passed, language related to this reconciliation period was inadvertently included in the rule. The section of the rule related to renewal appeals. So what's before you today would simply remove that language. We're happy to take any questions.
Thank you. Members, you've heard explanation of the bill. Any questions from any of the members? Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. Good afternoon to you. Are all references to the Achievement School District taken out of this by these rules?
Good afternoon. Ashley Thomas, General Counsel for the Commission. This rule does not address the Achievement School District. There should be no reference there.
All right. Thank you, Mr. Chairman.
Okay. Thank you. Representative Glenn, you're recognized.
Thank you, Mr. Chairman, and thank you for being here. Just a point of clarification here. It says if the commission finds that the local board of education decisions was contrary to the best interests of the students, LEA, then the commission shall be the authorizer. So does that mean that the commission can still override the school board? Is that what that's saying? I just want to be clear.
Yes, sir. That's current law.
Okay.
Thank you. Thank you. Senator Oliver, you're recognized.
Thank you, Mr. Chairman, and I just want to get clarification. If an LEA denies the charter school application, doesn't approve of it, but goes to the commission and they approve it, and there's this reconciliation period, does the school district are they still able to establish an authorizing agreement with that charter school, even though they didn't approve it?
Just for New Start appeals and during that 30-day reconciliation period, though I will say I know certain school districts have a policy in place now that they will not take back schools if the commission approves them.
Okay, thank you.
Thank you. Any other questions from the members? Seeing none, is there a public comment? Seeing none, have a motion for a positive recommendation? Have a second? May I have a voice vote in the House? All in favor, say aye. All opposed? Want to be recorded? One no? Three noes? Yep, and go to the clerk if you want to be recorded, so.
Then we gotta take a.
Okay, and now we need a roll call vote in the Senate. Madam Clerk, take the vote.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver votes aye. Senator Rose votes aye. Senator Seal, Senator Sutherland, Chairman Jackson
Aye.
votes aye. Chairman, you have 5 ayes.
Four.
Oops, sorry. So it moves forward with no recommendations from the Senate. It moves forward with no
Approved in the
recommendations.
House.
This moves forward, no recommendation in the Senate.
In the Senate, but a positive recommendation.
Positive recommendation in the House. Thank you. Okay, item number 11, the State Board of Education. If you'll come forward. Just to make sure your mic is on, identify yourself, and you may begin.
Thank you, Mr. Chairman. I'm Nathan James with the State Board of Education.
Rachel Supay, General Counsel with the State Board of Education.
Robin Ye, Director of Policy and External Affairs at the Department of Education.
So we're going to start out with a charter school rule.
If, before we get started,
Yes,
I
sir.
want to give the page number on this for,
228,
so
I
you can
believe.
identify this, page number 228.
Yes, sir.
Sorry about that. I didn't mean to butt in, but I want to be sure everybody was able to look at it. Thank you. You may
No problem.
continue.
All right,
Mr.
so we're
James.
oh
on Charter Schools Rule 052014-01.01.03 and .04. And so TCA 4913-126 authorizes the State Board of Education to make rules to effectuate the Tennessee Public Charter Schools Act codified in Title 49, Chapter 13. Additionally, House Bill 2922 by Speaker Sexton, Representatives McKenzie, Hardaway, Parkinson, Chisholm, and Slater became Public Chapter 1066 of the Acts of 2024, and they authorized the State Board to promulgate rules regarding the Opportunity Public Charter Schools. So this rule outlines various charter school and charter authorizer requirements, including the approval of a public charter school, allocation of state and local funds, and enrollment. Public Chapter 1066 creates the Opportunity Public Charter School, which serves students in grades 6 through 12, for which at least 75% of the students enrolled are at risk. The legislation authorized the State Board in consultation with the Public Charter School Commission to promulgate the rules. And the rules changes include the following. We did remove outdated school funding language, which was, of course, referring to the BEP, which is no longer in law. And we outlined the requirements for the first year for a student who transfers to an opportunity charter school located in an LEA other than the LEA in which the student resides. So we remember that under TISA, there are a lot of different differentials that make up the amount of funding that goes for a particular student. And so for the first year that a student would transfer to another district to attend one of these schools, they would come with the amount generated under TISA from the sending district, because that's where they live. And from that point forward, it would be based on the location of the school. So we defined what an opportunity public charter school is and the requirements regarding residential models. We removed duplicative language regarding the requirement that a local Board of Education specify the objective reasons for denying a charter school application, again, because it was duplicative, appears elsewhere. We clarified the order of enrollment preferences for public charter schools, and specifically those for opportunity public charter schools, which your first right of refusal is you're at risk. Second is economically disadvantaged. Third is those students who attend a school that have an articulation arrangement with the opportunity public charter school. So where those ease of transfer arrangements exist, those folks are third. Fourth would be siblings of those who are in the school. Fifth would be those residing in the LEA, and the sixth would be students outside the LEA if permitted by the authorizer. So it's not that that necessarily happens in every case. It's in the event that an OPCS, an Opportunity Public Charter School, is created that authorizes students to come in from other districts. Also wanted to point out that at-risk is defined in this statute, and it's a little bit different than what LEAs might think of as at-risk. So students at risk, according to this law, and according to the rules made in accordance with that law, are those who have been retained or chronically absent, have been justice involved. Maybe they're a parent or they're pregnant. There's been a history of substance abuse, or maybe the students themselves have been abused or neglected. So I say that specifically for those of you who are former educators and probably would perhaps think of a different set of criteria. We define those articulation agreements within the enrollment preference, and we delineated the verification requirements for students enrolling in an Opportunity Public Charter School. And the next steps, should an Opportunity Public Charter School fail to meet the 75% at-risk level for students. And that also is in the statute, and it's laid out here, because from what we observed the legislative intent to be, there was a desire to do something very distinct for students who were in a particular set of challenges. And so that means that an Opportunity Public Charter School which goes for 3 years without having that minimum of 75% of students at risk, could either choose to become a regular charter school or cease to function. So we did hold a public rulemaking hearing, and that was on the 8th of October 2024, and we had that both electronically and in person. And one public comment was offered at the hearing, and additional comments were submitted in writing. Public comments recommended inclusion of additional safeguards and programmatic requirements regarding the serving of the unique student population served. And in response to public comments and additional discussions with stakeholders, the State Board updated the rules language to further clarify enrollment processes and residential program requirements. I know Representative McKenzie, you had suggested that we would go through some of those comments. We're happy to do that, or happy to take that summary, whatever suits you, sir. And with that, we're happy to take questions.
Thank you. Members, you've heard explanation of the rule. Representative McKenzie, you're recognized, and then Representative Clemens.
Thank you, Mr. Chair. And I guess as far as the comments go, what my concern was that, like, I think from our conversation, some it makes sense you included.
Sure.
Those that you did not, for whatever reason, it's already in law, or was there any, so let me ask a general question. Was there any substantial comment that you all chose not to incorporate?
I'm gonna ask our general counsel, because she's got every one of them there. So
you may begin when you're ready.
Come on.
Thank you. Rachel Supay, General Counsel for the State Board of Education. Looking through the list of the public comments we received, we certainly incorporated the ones we could where appropriate, and they were substantive in nature. The ones that we did not incorporate largely were because, as you stated, they were already requirements set out in statute, and we felt it would be duplicative and unnecessary to restate those in the rule. So I'd say they were not substantive. A few asked for clarification about certain processes, and we felt that the best way to provide clarification on that would just be following up with the commenter to answer their question rather than amending the rule.
Okay, thank you. And my second question is, so as you described, for charter school, this Opportunity Charter School does not hit that 75% at risk for 3 years.
Mm-hmm.
They're reverted back to a regular charter school. There's a couple of questions in that. One, do they lose their residential piece to it? If they're residential and they go back to a regular, do they lose that? And those students are no longer part of that school. And then my second question on that is, does the LEA at that point have any say in them coming back into their area as this newly constituted school?
You may respond.
I'm happy to take that one. To clarify in a little more detail, if after 3 years, the Opportunity Public Charter School still has not met the 75% requirement each year, they would have to actually petition their authorizer to amend their charter agreement to become a regular charter school. So it wouldn't just be a unilateral decision. It would have to be made in agreement with the authorizer. And only Opportunity Public Charter Schools can be residential. So if they were to convert to a non-Opportunity Public Charter School, they would just be a traditional charter school without a residential model.
Members, Representative Clemens, you're recognized.
Thank you, Mr. Chair. So yet again, there's rules in here for calculating, allocating, and dispersing public charter school funding. Is there anything in here that tightens up the timeline for reimbursement to the TEAs for the students who transfer right back into the public school or the traditional public school rather within the school year to ensure that they have adequate funding to educate that child for the remainder of that year?
So I know that there is, and I'll be happy to yield to both council and also to the Department of Education where the implementation and the funding process takes place. I know that there's a true up that takes place several times a year, multiple times a year, in order to go after that and make sure that if there's a transfer, that the funds are right there with the student. In terms of the specific language of the rule, happy to yield to our general counsel and anything further from the Department of Education, which has the Office of Local Finance charged with this process.
I don't have anything to add beyond Mr. James' statements, but certainly if Robin Ye at the department would like to comment.
Thank you. Robin Ye, Department of Education. Mr. James is correct in that with charter school funding, the TISA funds are provided to LEAs, and if those LEAs are authorized in charter schools, they're responsible through the law of allocating those funds and dispersing them to their public charter schools that they authorize. This rule, we are not drastically amending the way that has worked for years. And so the red lines that you see here is simply removing references to the way that funding worked under the BEP because we are no longer under the BEPs.
Thank you, Mr. Chairman. So again, my question is, we've just dealt with rules and we continue to deal with rules that remove authorization authority from the LEA and place it with the state board that was created specifically to override the local officials. So with that duty as an authorizer comes the responsibility for calculating and allocating those funds to the LEA. So in that case, are we doing anything with this rule that specifies whether it's the LEA as authorizer or whether it's the state commission as authorizer? Are we doing anything to specify and to ensure that this, beyond the calculation and allocation, that there is a reallocation? I realize that gentleman said that there were recalculations throughout the year. I'm not sure who's doing those, LEA or the authorizer in general. And again, the logistical maneuvering to get that money to the LEA who has to spend that money in real time to educate that child. That's my question.
You may respond.
The calculating is done by the Office of Local Finance in the Department of Education, just as it is for all the public school students of Tennessee. Anything further, I'd be happy to yield to the department on.
I'm happy to clarify my comments earlier. So as you can see in the rule, there are separate sections regarding the initial allocations and interim and adjusted allocations that are made throughout the year. So at the beginning of the year, when the department is determining TISA allocations for school districts, we are also calculating those interim allocations for public charter schools and the amount of funds in which the authorizer is required to provide to their public charter school based off their student enrollment. As you all know, students move in and out of schools a lot. And so if there is any situation in which a student is leaving a public charter school in the middle of the school year, their interim allocation that is made at several points during the year will be adjusted. And that adjustment is provided to the authorizer as well to adjust their payments to public charter schools. If that helps clarify your question.
Thank you. I appreciate that. Thank you, Mr. Chairman. And so with that, I guess the concern is the money getting to that LEA in real time as opposed to it being reallocated on a spreadsheet, whether or not that money's actually getting to that, because most of these figures are based on the previous school year's enrollment. Again, there's words in here with regards to calculation, TISA allocations to charter schools. And here we are creating a charter boarding school, for lack of a better term, that is single sex. My question is, are additional, because we have a baseline funding under TISA per student. I suspect these private charter schools receive, they're supposed to receive the same amount that a child would receive in a real public school. Are there additional costs associated with the boarding? So are the boarding charter schools getting a higher TISA allocation than a traditional public school specifically for that boarding?
Response?
I'd like to point a couple of things out. First of all, these would be public schools. When a statute's passed, like this one, that contemplates the concept of a residential model for a public charter school, which is what this contemplates, you also have to ask yourself, how would such a school get started or get funded, because they would have only the amount of money that comes from the state for the student's K-12 education. So there are certainly questions there in terms of where extra money would come from in the event that ever happened. So our task at the State Board of Education is to take the statute as it exists and put together the best set of rules that we can to effectuate that. There's nothing in here that contemplates any extra money that would go to a school because it was a residential model, but it is statutorily authorized. So our rules provide the framework to the best extent that we can do so, without a great many examples of that, to have it ready. I don't know if that helps, but it's certainly worth asking.
Thank you, Mr. Chairman. I appreciate the challenges with which this body presents the department in promulgating rules following these and the additional costs that we've placed on the system with these boarding charters. So again, if TISA is based on, and we talked about it, money following the child and being per child funding, I would assume that there would be additional cost for each child who is in a residential setting, regardless of what you think about that type of school or that residential setting model being charter operated. I would assume there's going to be additional cost above and beyond a traditional public school that doesn't board those students on a per student basis as TISA is structured. That's my concern. Next is the Achievement School District is explicitly referenced in here on page 245. So I heard a lot of celebration about eliminating the ASD in the past year, and following up on my colleague from Shelby County's question earlier, why is the Achievement School District still in here? I assume it's because we didn't really abolish the ASD, we just changed the model.
Representative Clemens, the statute doing away with the ASD takes effect in the 26-27 school year, and we're not there yet. And so the rule must contemplate the statutory situation and posture that the legislation was passed in.
So you're going to come back with rules in the next year that eliminate all references to the ASD, but that would seem a little odd considering that we're continuing the ASD model. We're just, instead of the state taking over those schools, we're just chartering them and turning them into charter schools. So what's the plan of action there moving forward?
Representative, I would say to this body is, as long as the legislature makes changes to education, we'll be coming back with rules. So as far as right now, at the moment, the law still contemplates this entity being in existence until 26-27. So it's just part of our due diligence to try to make the rule reflect the law as it is now. But I promise you we'll be back with any number of revisions for any number of rules that we have, because this is a ever-changing and dynamic environment.
Thank you, Mr. Chairman.
Okay. Representative Hardaway, you're recognized.
Thank you, Chairman. And thank you to Chairman Clemens for that warm-up. The ASD, when we're looking at the articulation agreement, we're looking at the enrollment preferences, et cetera. Are you saying that none of these rules apply today? None of these rules will apply to the ASD until 26, 27, and we phase it out?
Well, I'll just say this and then I'll yield to learned counsel. What I was saying is that references to the ASD exist in our rules because the ASD still exists. That's all I was saying. I didn't say make any remarks about articulation arrangements with the ASD. I'll be happy for the council to offer anything.
You can respond.
I just wanted to also add that right now, we don't have in existence any opportunity public charter schools in Tennessee. So there is currently no overlap, and there won't be an overlap between any schools that are ASD and opportunity public charter schools, given that we only have 2 ASD schools left for the upcoming school year. And we have 2 applications right now pending for charters to create a opportunity public charter school. There wouldn't be a situation where any of the ASD schools would also be considered an opportunity public charter school.
All right, to be clear, you said that there are none currently, and they'll be phased out in 26, 27.
There are,
And-
sorry, go ahead.
And these rules will not catch those who are still to be phased out?
That's correct, in that there's 2 achievement school district schools left, and the 26-27 school year will be the final year for those 2 schools. We have no opportunity public charter schools right now in Tennessee. That is a long application process, as you know, that involves votes by the local board and potentially appeals through the Tennessee Public Charter Commission. Right now, we have 1 application to open an opportunity public charter school with Metro Nashville Public Schools, and a 2nd application pending with Memphis Shelby County Schools. But neither of those applications have been fully voted on yet, so we don't know yet what the outcome will be for those 2 applications. As soon as we know that information, though, we would be happy to provide an update.
All right, my concern is twofold. Number one is I think the ASD, and nobody in here is going to disagree, has been a dismal failure. Those charter schools, if they're getting any kind of preference to become opportunity charter schools, then I would object vehemently. The other is that those children who have been victimized by the dismal work that the ASD charters victimize them with, should get some special enrollment preferences. And you might want to put your response towards an email to the chairman. Thank you, Chairman.
Thank you. Any other questions for any of the members? Seeing none, is there public comment? Seeing none, I need a motion. Have a motion for positive recommendation and a second. Okay, first we'll take a roll call vote in the Senate. Madam Clerk, take the roll.
Senator Bowling, votes aye. Senator Crowe, votes aye. Senator Hatcher, Senator Kyle, Senator Oliver, votes no. Senator Rose, votes aye. Senator Seal, Senator Sutherland, Chairman Jackson.
Aye.
Votes aye. Chairman, you have 4 ayes, 1 no.
Thank you. And voice vote in the House. All in favor say aye. All opposed? If you want to be recorded as no, check in with the clerk. It passes with a positive recommendation and in the House, no recommendation in the Senate. Thank you. Okay, last item on the agenda is the State Board of Education again, public charter schools, and you may begin. Again, identify yourself if you would, just for the record.
Thank you,
And you may
Mr. Chairman. I'm Nathan James with the State Board of Education. We're looking at, and I will make sure that I get the entire name on the record. This is School Safety 05200102-.30. That's on page 253 of your rule packet, and this is a repeal. TCA 491302, I2 requires the State Board of Education to adopt rules and policies protecting the health, safety, and welfare of children in K-12 public schools. This rule repeals State Board School Safety Rule 0520-01-02-.30, as the requirements for the school safety are already in statute, and there is no need to duplicate them in rule. Through the support of Governor Bill Lee and the Tennessee General Assembly, the state has made unprecedented investments in school safety, and the requirements for school safety are included in the Schools Against Violence in Education Act. The SAVE Act established specific and consistent requirements for districts related to providing a safe school environment, including the formation of district and school safety teams and requirements for the development of comprehensive safety plans. In addition, Tennessee law previously required school districts within the New Madrid fault line zone to conduct earthquake drills. The requirement was removed from the law in 2018, and therefore the state board's rule requirements that districts within 100 miles of the fault line conduct at least 2 earthquake drills a year was also removed. The State Board of Education held a public rulemaking hearing on Chapter 0520-01-02-.30 on 25 July 2024. We held it both in person at 500 James Robertson Parkway and via WebEx. We had no public comments submitted. Recalling that by the removal of this rule, nothing goes away because every bit of it, except the last final reference to an outdated law, is elsewhere in statute.
Thank you, members. Heard the explanation of the bill, of the rule. Any questions? Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. To be clear, are there statutes that address the New Madrid fault and earthquake drills?
I'll yield to our general counsel to make sure. I know that one went away, but I don't want to give you an encyclopedic response and be wrong slightly. So
you may give a response.
The statute specifically naming the New Madrid fault line was the one that was taken away in 2018. But there are still statutes that require every single school district in Tennessee to have an emergency preparedness plan. And that has to take into account all sorts of whether natural or unnatural disasters to make sure that students and staff at the school are prepared for those. And those do include preparedness for potential earthquakes.
All right, so there's a definition for natural disasters that includes earthquakes, and it applies statewide, not merely to West Tennessee or Middle Tennessee. It also includes East Tennessee.
I don't know specifically, without pulling it up, if the definition of a natural disaster, if there is one in statute that includes earthquake, but I did do some research ahead of this meeting, thinking that this question might come up, just to confirm that districts are still required to have earthquake preparedness plans.
All right, if you could address that in an email.
Sure.
One of those many emails to the chairman. I appreciate it.
We can do
Thank
that.
you, Chairman.
Thank you. Any other questions for any of the members? I do have one real quick, just to be sure, because that's a big issue over in West Tennessee, the New Madrid fault, running along from New Madrid, Missouri, all the way down from St. Louis down to past Memphis. And you said preparedness for emergency or issues that, so the preparedness for earthquake would be different from tornado or for flood or whatever. What is that spelled out as what the what you do for an possibility of an earthquake on the along the New Madrid?
My understanding is that districts have a lot of flexibility under the law to design a plan that's appropriate for their district. So in a district that perhaps is near a fault line, they might want to take some additional earthquake-related precautions, and they might still continue to do these 2 earthquake drills or more per year. There's nothing that's stopping them from doing that. But there's also nothing that would stop a district who's perhaps very far from an earthquake fault line, I don't know if that's the technical scientific term for it. I apologize.
That's
But,
right.
Another district who is perhaps in an area where tornadoes are more common might choose instead to prioritize resources there. And like I said, the emergency preparedness plans include planning for things that are not natural disasters, but might be an active school shooter drill, for example. So they're really meant to be more encompassing than what was previously in the law about the New Madrid fault line.
Okay. Thank you for that response. I appreciate it. Anybody else have a question for the Senator Bowling? You're recognized.
Thank you, Mr. Chairman. I just wanted to point out that the Fort Payne fault line runs through most of eastern Tennessee. So you folks in western Tennessee, we're all going to have to be looking out for earthquakes in Tennessee.
Thank you. Any other questions? Seeing none. Is there a public comment? Seeing none. I need a motion. A motion for positive recommendation. Have a second. We'll take a voice vote in the House. All in favor say aye. All opposed? Okay, and we'll do a roll call vote in the Senate. Madam Clerk, take the vote.
Senator Bowling votes aye. Senator Crowe votes aye. Senator Hatcher, Senator Kyle, Senator Oliver, Senator Rose votes aye. Excuse me, Senator Seal, Senator Sutherland, Chairman Jackson
Aye.
votes aye. Chairman, you have 4 ayes.
We have a positive recommendation in the House, moves out with no recommendation in the Senate. Okay, members, that was our last item. Representative Clemens, you're recognized.
Thank you, Mr. Chairman. I have a personal order. I should have done this at the beginning. I apologize.
Oh,
but I
you're
just-
recognized.
Thank
Yes,
you,
sir.
Thank you, Mr. Chairman. I've got a personal, I just want to take a moment to honor the life of Miss Erin Clinton Walsh Donick. She was taken from our community too soon at the age of 54 after battling cancer for the past year. She has been a leader in our nonprofit community here in Nashville area for over about 20 years. Most recently with the STARS program, and before that, the Boys and Girls Club. She spent her entire career working with students and youth and who were facing challenges. So I just want to ask this committee, please extend your prayers and keep in your prayers the family of Ms. Donick, Willie Donick and his children who've lost a spouse and a mother. Thank you, Mr. Chairman.
Thank you. Thank you, Representative Clemens, for recognizing Ms. Donick. Any other questions? Any other responses? Seeing none, for the good of the order, we will stand adjourned.